Have you ever wondered what happens when personal data needs to cross international borders, but the usual safeguards are not available? It is a complex challenge, especially when dealing with the robust protections of the General Data Protection Regulation. GDPR derogations serve as specific exceptions that permit data exports from the European Economic Area to third countries, even when a formal adequacy decision or appropriate safeguards are not in place. These derogations act as a safety valve, allowing for necessary data transfers under very particular circumstances, thereby impacting how organizations can move data internationally. The core reason these derogations exist is to facilitate essential data transfers that cannot otherwise be conducted through standard mechanisms like standard contractual clauses or binding corporate rules. They are not meant as a general bypass. Instead, they are specific conditions outlined in Article 49 of the GDPR, reflecting situations where public interest, vital interests of data subjects, or specific contractual needs necessitate the transfer. Their application is always interpreted narrowly by data protection authorities, emphasizing that they are exceptions, not alternatives, to the primary transfer tools. Practically, this means an organization might rely on a derogation for a one-off transfer that is necessary for the performance of a contract with the data subject, or perhaps for important reasons of public interest. For example, if a medical emergency requires transferring a patient's health data to a non-European Economic Area hospital immediately, and no other safeguards are feasible, a derogation based on vital interests could apply. However, this is not a routine solution for mass data transfers or systematic processing outside the European Economic Area. It is crucial to understand that these derogations are distinct from the more common transfer tools and are always considered a last resort. Supervisory authorities, who oversee compliance with data protection laws, rigorously scrutinize their use, looking for clear evidence that the specific conditions are met and that the transfer is truly occasional and necessary. This strict interpretation underscores the General Data Protection Regulations' commitment to ensuring a high level of protection for personal data, even when it leaves the European Economic Area. Ultimately, the impact of GDPR derogations on data export is that they provide a narrow pathway for transfers in exceptional cases, but they do not diminish the overall requirement for robust data protection. Understanding their limited scope and strict conditions is essential for any organization navigating the complexities of international data flows, ensuring compliance while enabling necessary global operations.